Hello everybody, my name's Kit Barker and I'm here to talk to you very briefly about LAWS5221, which is the elective I'm running next semester, entitled Tort Claims Against Government, Public Wrongs, Private Remedies. So the idea of the course is to look at the remedies that you or I can obtain for the consequences of bad public decision making. So these consequences, they could be financial, they could be emotional, they could be listed in terms of physical injury or property damage or sometimes even loss of liberty. Public law, you may remember, can get bad government decisions changed, or it can force government to reconsider those decisions, but what it can't do is give private individuals who've been harmed by those decisions any degree of compensation or private remedy. So this course is examining the circumstances in which private remedies might be available against government in respect of poor government decision making. Lots, I'm afraid, of examples of poor government decision making in the press recently. So you've got the robo-debt scandal, haven't you, a number of years ago, in which literally tens of thousands of individuals suffered financial and psychological harm as a result of the implementation of a completely illegal government automated debt recovery system. And the evidence is that it's highly likely that agents of that system knew perfectly well that it was illegal, that it might be illegal, when it was implemented. Other examples in recent years, going back a few years, there's the largest ever settlement of false imprisonment claims in Australian history, resulting from the illegal detention on Manus Island of refugee detainees. Those of you who are alive to environmental debates, of course, may be aware of the decision also 2 years ago, I think it was, to 2020, might have been 2021 actually, of a court that an environmental minister, when approving coal mining projects, has a duty of care in the law of negligence to future generations of Australians to protect them, to take reasonable steps to protect them when approving the application against the potential consequences of climate change that the approval might lead to. Consequences in terms of physical injury, property damage and environmental harm. Now that case got thrown out, but the interesting thing about it was that private citizens, in fact it was a group of teenagers, decided that they had to have recourse to private law, to the law of tort in particular, to try to get anything done about bad public decision making. So I won't say more about the course content because you can discover that by scrutinising the ECP, but we basically look at principles and policies and arguments in and around government responsibility, government liability for its wrongdoing. We look at the history of state immunity against civil claims, which has dissipated, but which some might say has been reintroduced by certain principles under the Civil Liability Acts. We look at cases of the tort of misfeasance in public office, which is deliberate public wrongdoing. We look at a whole variety of different cases where there have been welfare failings, which are normally actioned in the law of negligence. So failings in policing, failings in immigration detention, failings in protection of vulnerable individuals who are mentally at risk of self-harm, for example. We look at devices which have been used by the state to restrict their liabilities. We look to some extent also at alternative compensation systems for individuals who've been harmed outside of the tort litigation system. In terms of the way in which the course works, it's a seminar-based course. There are no lectures. So there are comprehensive materials, and there's a brief video guidance, probably no more than 15 to 20 minutes each week, to help you to understand how best to do the reading. But the reading work is really up to you to do, and you need to do it before you come to the seminars. The seminars aren't recorded. They're 3 hours long, they're divided into 3 bits. Usually the first part we spend discussing the ideas, then there's normally a sequence of oral presentations by students in the class, and then there'll usually be class exercises of some sort as well. The whole idea of the course is to give you maximum liberty to understand and explore the subject matter of the course for yourselves, and so the assessment techniques are all driven by that aim. So you do an oral research presentation exercise, either individually or in teams in class for 25 minutes. That counts for 25% of your mark. There is a research-based problem-solving exercise, and then there is a research essay where you can either pick from a variety of predefined topics which I think are interesting, which are topical, or you're at liberty to pick whichever other topic you want. The course is challenging, but I think very interesting. It got 4.9 out of 5 the last time it ran in 2020. Sometimes we're lucky enough to get Justice Edelman coming along to talk about it. I don't know whether that'll happen this year. And sometimes I drag in some of my colleagues to talk about human rights or environmental perspectives or constitutional law perspectives to the course as well. So it's an interesting mashup or mix between public and private law. I hope very much you enjoy it. I hope you can join me for it. Thanks very much. Bye for now.